talk about a topic that we have a lot of personal experience with, and that is, what do you do if you are an intellectual property owner and your intellectual property is being infringed upon by a Chinese company? How do you sue that Chinese infringer in America? How do you get jurisdiction over them? And Mr. Lesowitz here, you have a lot of personal experience with this. We've had a few cases where we represent video game publishers whose games have been infringed by a Chinese company, and liability really wasn't a big deal. It was practically admitted. So, how were we able to get, and I'll give away the ending of the movie in this respect, how did we get personal jurisdiction over a Chinese infringer that is not physically present in America?
The big thing the court wants to see is that the defendant, the infringer, purposely did business in the United States, knew it was doing business in the United States, purposely did business in the United States. It's not enough just to say the Chinese company infringed my game. That's not really what the court is looking at. That is a factor, but it's not the only factor. The court wants to see things like, for instance, a big deal in our last case where we got the court to exercise jurisdiction over the Chinese company was that when you upload an application onto the Apple App Store, it asks you to select which countries you want your game to be uploaded in, and the company, the Chinese infringer, chose to have the game made available on the U.S. App Store. If they hadn't, I think probably would not have gotten the court to exercise jurisdiction in the case. Another thing the court looks at is how much business the company does in the United States, although in our last case the company did not do a huge percentage of its business in the United States. And anything that you can show that this company was purposely doing business in the United States and targeting the U.S. market.
So, with respect to mobile games and apps, they're distributed primarily through the Google Play store and the Apple iTunes store. Now, do you have a feeling for what if the Chinese defendant did not selectively or actively select to distribute in America? Do we have any indication of how that would affect things, that they just put it up on the iTunes store and it was available to the world without any sort of selectivism?
So in that case where that hypothetical, because the Apple, for Apple and Google, there is this process of selecting where the application is made available. But I would say that if it's a application where they affirmatively chose only to distribute in China, it would be a difficult case to get jurisdiction, because if it's just purely infringement that's occurring in China, the appropriate remedy is to go sue in China, and good luck with that. The fact that you are using, though, the Apple and Google, which are based in California, that is a positive factor for getting jurisdiction, because you're using a U.S. entities to do the infringement. However, courts are skeptical whether or not that by itself is enough, but definitely is a positive factor.
I see, and can you explain what sort of percentages of infringing sales inside America versus in China, for example? What sort of mix, what sort of ratio we had? I think in ours it was less than 5%.
Yeah,
is that correct?
Yeah, it was in dispute, but it was single digits in percentage. That was what the court at least used as the number, and definitely did a lot more business in China than they did in the United States. There still were, I believe, into the tens of thousands of downloads in the United States, but they got millions of downloads in China. But once again, they used Apple, they chose to have the game distributed in the United States, and there were about 5 or 6 factors that the court looked at. But the big question the court looks at is, did this infringer knowingly use the U.S. market. Another thing that would help is if it's an American distributor, did it know that it was infringing an American distributor's game? That also helps. Now, in our case, it was actually the last one we did, and one we did in the past, it was actually a foreign company whose game was infringed, and the court still found jurisdiction.
I see, and that's interesting, and we'll have Steve chime in here as our resident copyright wonk. So, Steve, if you're a European content provider, you've secured a U.S. copyright. Well, you got to come to America to enforce it, right? Where the hell else are you going to go? If you're a Swedish video game company, you're not going to enforce a U.S. copyright in Sweden. You're not going to go to China. So, I think in some of the scenarios we've seen, you have to come enforce it here in America. Isn't that correct?
Yeah, absolutely, and especially because for a lot of these companies, their primary market is going to be America as well. So not only did you get the copyright in America to protect your rights, but because it's probably a very significant portion of your market, so you're protecting that. And the American courts are the place that you want to enforce your American copyrights.
But I do think, guys, it makes it a little tougher sledding for us representing a non-American company, to your point, Scott. I mean, it's more difficult to make that argument that the Chinese infringer knows it's targeting the conduct towards America. One last point let's talk about quick before leaving is a lot of people ask us, well, do you get money out of these Chinese infringers? Because a lot of intellectual property owners experience frustration and don't know how to collect. In this scenario, we are actually able to many times, right? Because we have control. The iTunes store and the Google Play is where all that content is monetized, and a lot of the money comes in through those portals, which are in Northern California.
Yeah, that's a big deal, and something that if the entity suing or that wants to sue the United States and wants monetary relief, one thing to look at is where is the company getting its revenue from? Because when it's flowing through, for instance, AdMob or iAd, so they're using Google or Apple to monetize their games, that's really easy to go to Google and Apple and say, hey, we have this $500,000 judgment. This money that's coming in for that company belongs to us. It's much harder if they're using almost exclusively Chinese advertisers to actually collect on the judgment. One thing though is that if you're suing a company that does a lot of business on the App Store or on Google Play, a big incentive for them to settle a case and pay money is if they do a lot of business on the App Store and on Google Play, even if they're not using it to monetize the games or the apps, whatever they are, because they don't want to have all their games banned from Google or Apple and lose essentially their brand recognition, their whole marketing model.
So we'll conclude by saying, with respect to mobile gaming, content available through the iTunes Store and Google Play, there are options, there are paths to success for intellectual property owners in suing and gaining jurisdiction over Chinese infringers. That's it for the Cyber Liability Report this week. We'll see you next time.